So hello, everyone. Thank you for joining us for today's event on the scourge of social inflation. My name is Brimhall. I'm a manager on the Federal Affairs team here at R Street, and I'll be moderating today's discussion. I'm very proud to introduce today's speaker and the author of our recent report on social inflation, Jerry Theodorou. Jerry is the Policy Director of Finance, Insurance, and Trade at the R Street Institute. We'll be diving into a study today, so let's get started. Hey, Jerry, good to see you.
Hi, thanks, Canyon.
Absolutely. All right, so the first question that I wanted to ask you is big picture. What is social inflation and why did you write a study on it?
Yeah, thanks, Canyon. Thanks for moderating, and thank you all for participating in today's call, and for those that are listening to the recorded version. And Canyon, I'd also like to thank you, by the way, for this opportunity to wear a jacket and tie. Now, for those that are listening years into the future, they're going to ask, well, what did he mean by that? But thank you. So what is social inflation and why did we do a study on it? Social inflation, briefly defined, is the current trend for ever higher jury verdicts and out-of-court settlements whose value is driven by factors that are unrelated to general inflation. And they're out of proportion to damages that are sustained by plaintiffs. So this trend leads to larger losses paid by insurance companies, which leads to higher insurance rates, which leads to higher costs borne by businesses, which in turn are passed on to ordinary citizens in the form of higher prices for goods and services. So it affects everyone. That's why it's important. And it impacts the competitiveness of business. It's bad for the economy. And the drivers of social inflation, as I mentioned, are non-economic. And that's distinguished from economic factors. We're hearing a lot today about economic factors which affect inflation, such as the Consumer Price Index, the CPI, supply chain constraints for building materials, for microchips, medical inflation. But non-economic factors which drive social inflation stem from societal attitudes that have to do with responsibility and blame. And those attitudes influence jurors and judges' decisions and the magnitude of court awards.
Gotcha. Okay, I obviously have multiple other questions, but before I get into those, I do want to flag for the webinar. If you have any questions, please use the Q&A function in Zoom. You put your question in there, I will take a look and get to it at the end. We'll try to leave a little bit of time. But my next question, following up on what you just said, there seems to be some controversy regarding whether social inflation is real or not. Not everyone agrees that social inflation is worth the attention it's getting. Can you comment on the controversy?
Well, yes, Canyon. It's true that there is a cadre of what you might call social inflation deniers. The social inflation denial argument is advanced most forcefully by what we could call consumer watchdog organizations, sort of the successors of Nader's Raiders. And as a matter of fact, less than a couple of years ago, there was a big report, it's about 70 pages, that was written by the Consumer Federation of America, co-authored by the Center for Justice and Democracy. Both of those grew out of the Nader movement. And they declare in the report that social inflation is not real, but it's a myth, it's a fiction or a hoax. As a matter of fact, the title of the report is a mouthful, and it's quite provocative. The title of the report I referred to is, and here I quote, "How the Cash-Rich Insurance Industry Fakes Crises and Invents Social Inflation." Now, here's a quote from the report. "In the current run-up to the new hard market, the insurance industry needed a new public relations term to make the case for higher rates. It settled on a new name to describe its current interest in raising prices: social inflation. But it is a hoax, a way for insurers once again to try to deflect blame away from the industry's own accounting and underwriting practices as an attempt to justify unnecessary rate hikes." End of quotes. Now, I'd like to put those comments into context, because the same organizations that wrote the report have a history of take off the gloves insurance industry bashing, calling the insurance industry greedy, collusive, opaque, intransparent. And this goes way back. In 1983 to 1986, for anyone that remembers the liability insurance crisis, in the depths of that crisis, the consumer groups were saying back then also, there was no crisis. But what happened in those 3 to 4 years is that 60 insurers became insolvent because lawsuits and liability claims were exceeding premiums. I mean, that was a full-blown crisis. And if we fast forward from the 1980s to about 2000, those same groups were maintaining that medical malpractice insurers were also inventing a crisis. The reality is that losses were unsustainably higher than premiums for medical malpractice. As a matter of fact, St. Paul Insurance Company, which at the time was the largest medical malpractice insurer, pulled out of the market completely because the business was underpriced, not overpriced. In their last year in the medical malpractice business, in 1999, St. Paul collected $500 million in premiums and paid out $1 billion in claims. Now, that's not a good business model when you're charging $5 million for something that it costs you $1 billion to produce. And Jay Fishman, who was the CEO of St. Paul, said in an earnings call that continuing in the business in that way was a very threat to the solvency of the company. And that would have been a huge blow to St. Paul, which had 10,000 employees. You see, insurance is a tough business. And to bring it home, to bring it up to date, losses from last summer's Hurricane Ida have already caused the failure of 3 Louisiana insurers. Now, there's another variant of denying that social inflation is real. And this is to say that, well, we've got long memories. We've seen this movie before. It's not the first time. And the increase in rates now and losses is just a repeat of a phase of the familiar insurance market cycle. What is the insurance market cycle? Well, it's characterized by alternating periods of rising insurance rates. Rates are going up. That's the hard phase of the cycle, followed by a phase of falling insurance rates. That's the soft phase. And the cycle is driven by competition among insurers. The insurance industry is very competitive, thousands of them out there in the US. And this competition causes insurers to lower their rates to attract new business, followed by responding to underwriting losses from underpriced business by raising rates. And by way of fact-checking the statement in that report that social inflation is a term that was just now invented by insurers, the reality is that the term social inflation was first encountered in Berkshire Hathaway's 1977 letter to shareholders. And in that letter to shareholders, the sage of Omaha, Berkshire Hathaway CEO, Warren Buffett, wrote that social inflation was, and here I quote, a broad definition by society and juries of what's covered by insurance policies. Now, there is admittedly some degree of cyclicality in social inflation, which relates to pendulum swings in tort climate, which in turn are related to the political environment. In periods that are populist, there's more anti-corporate sentiment, anti-business, and litigation more readily, more easily targets companies and insurers that are perceived to have deep pockets. And in business-friendly periods, such as the 2 George Bush administrations of the 1990s, tort reforms are introduced to place checks on court awards that are out of hand, that are outside. And today, we're in a more populist period with an uncharacteristically anti-business administration just prior to the current Biden administration, which is continuing today as well.
Gotcha. Okay, so we've heard this argument that social inflation is not real. It's just a hoax. Can you tell me why you think social inflation is real?
Right. Why do I think social inflation is real, Canyon? Mainly because numbers don't lie. And here are some numbers for you. In 2001, the median cost of a single fatality award was about $1.5 million. Today, it's about $4 million. And if we take into account inflation from 2001, the $1.5 million of 2001 would be about $2.25 million today, but it's $4 million. So you have a trend which is much higher than the CPI. Here's another one. But many of the largest awards are related to truck accidents, truck accident litigation. The American Transportation Research Institute, the ATRI, which produces really good research, found that from 2010 to 2018, the size of court verdict awards against trucking companies increased by over 50% a year, while standard inflation and healthcare costs were growing 1.7% and 2.9% for healthcare. The ATRI reported further that the average verdict size of trucking accident lawsuits over $1 million rose by a factor of 10 from 2010 to 2018, from 2.3 million in 2010 to over 22 million in 2018. Those are big numbers. And following on the truck accident litigation, here's some news which is not in the report, because our study, The Scourge of Social Inflation, was released on December the 6th. But just a couple of weeks ago, in January, a report was produced by a reputable actuarial consulting firm, and it shows that truck accident litigation has grown. It features more involvement of attorneys on the plaintiff side and therefore higher court awards. And here's another one, another factoid. In New York City, the Metropolitan Transit Authority, the MTA, for those that ride the subways in New York, the MTA saw its personal injury payouts rise from $43 million in 2007 to $150 million in 2019. This is just over a decade and more than tripling.
Wow, those numbers are very striking. Wow. Okay, so you've made the case that social inflation exists. What's driving social inflation?
Right, Canyon. There's multiple drivers of social inflation. It's not just one, but if I were to focus on the strongest, I'd say that the strongest driver of social inflation is changes in the structure and the behavior of the plaintiff bar. In recent years, personal injury lawyers have developed new strategies that are effective to win large court awards, whether through jury verdicts or out-of-court settlements, which are more common. The defense bar, by contrast, has been slower and less successful to push back against nuclear verdicts, which are verdicts of $10 million or more, and they're out of proportion to damages. This has resulted in historically large losses across various liability lines of primary insurance and reinsurance. Other drivers of social inflation include attorney advertising, litigation funding, phantom damages, and the defense bar on the back foot in a world of torts with swelling awards. But let's start and peel back some of the layers of the onion on the changes to the structure and the behavior and the techniques of the plaintiff bar, which I maintain is the strongest driver.
Please.
Thanks. Courtroom arguments that are rooted in arousing an emotional reaction from jurors have historically been prohibited in the courtroom. Federal Rules of Evidence Rule 403 authorizes trial courts to exclude evidence that induces decisions on a purely emotional basis or leads to decisions on an improper basis, which are commonly an emotional one. Now, notwithstanding Rule 403, civil trials involving a severely injured plaintiff typically do arouse emotional responses, emotions of sympathy or pity. But the plaintiff attorneys have changed it so that the purpose is not to arouse sympathy or pity, but to get anger on the part of jurors. And if we review the language and look at the tone of the summations, the closing arguments in litigation that's resulted in some of these enormous nuclear verdicts, it shows that the plaintiff bar really has effectively dispensed with traditional legal restraint on stimulating emotions. And it's not averse to stoking juror anger. Quite the contrary. There was a book written in 2009 by David Ball and Don Keenan called Reptile, the 2009 Manual of the Plaintiff's Revolution. And this book and its contents has had a major impact on courtroom plaintiff attorney strategies. The Reptile Strategy, which is described in the book, and some people say that After the release of this book, the whole world changed. Strategy involves convincing the jury that jurors are the protectors of the community, that they have to keep the community safe by punishing bad corporations, that corporations put profits over people and they put profits over safety, and the jurors should punish defendants. Now, this is interesting because civil litigation is not supposed to punish, it's supposed to compensate. The economic damages are one thing, but then you get into the other two components where the non-economic, the pain and suffering, and then punitive damages. That's where the dollars typically end up. But again, the role is to provide adequate compensation for people that are injured and they deserve compensation. But again, these nuclear verdicts have a lot of fat in these other two areas of the awards. And today, plaintiff attorneys are taught to employ something that's called psychodrama in the courtroom. As a matter of fact, it's a very prominent element at a training center for plaintiff attorneys, where they use professional actors as teachers, as instructors, to teach the techniques of the stage. And psychodrama, as you might think, is a cross between applied psychology and the thespian arts, the stage. And anchoring is another one. Anchoring is the plaintiff attorney practice of asking for a court award that is above and beyond what's historically been considered reasonable. And it remains excessive when compared to comparable cases, even when they're reduced in remitter. Remitter is a legal term which means the reduction in the award. So if the jury comes back and says we award 10 million, the judge may strike it down and say, make it 2 million. So that's remitter. Now, if you text mine the description of a new trial lawyer's course, and this description of the course has got 262 words. If you do a text mine of that document, this course focuses on asking for the money. The word money appears 12 times. The word justice appears once. Words matter. Well, let's look at some of the structural changes of the plaintiff bar, which I argue has seen an increase in its intellectual and financial capital. Today's plaintiff bar is characterized by a collegial, cooperative model. Plaintiff attorneys readily share strategies, they share information, they share witnesses. National plaintiff firms typically work as co-counsel with local personal injury firms. Seminars and training, like the one I just mentioned, offer instruction in the most effective techniques. Whereas your grandfather's personal injury firm was characterized by generalist solo practitioners, more than ever today, the bar has knowledgeable, specialized, talented, aggressive, successful attorneys. An increase in attorney advertising is also contributing to more litigation, particularly for class actions. The other day, I got 2 calls on my home phone asking if I wanted to join and be on a class action for talcum powder. Attorney advertising was illegal until 1977, but since 1977, attorney advertising has expanded from listings in the yellow pages, if anyone remembers what that is, that's telephone books. It's expanded from yellow pages to billboards that are on the highways we see all the time, advertisements on city buses and bus benches, and an advertising inundation on television, radio, the internet. And there are numbers that are associated with the rise in attorney advertising. It's risen, Canyon, by 70% since 2008 in dollars. I talked about the growth of financial capital of plaintiff firms. Well, one of the contributors is litigation funding or litigation financing, which is the practice of third-party firms investing in lawsuits, providing capital to finance litigation. The capital in the litigation finance comes from investors, from outside investors, third-party investors. And litigation funding has become an asset class, which is uncorrelated with capital market risks. So for investors, whether institutional or individual, family offices, it's a diversifying asset class, unrelated to the stock market or the bond market. But it's ethically problematic because you've got third parties that can influence the course of litigation for profit, for their profit, rather than attorneys that act in the best interests of his or her client. From 2019 to 2020, in just 1 year, the number of active litigation funders in the United States grew by 15%, and their combined assets under management grew by over 18%, reaching over $11 billion. So it's a burgeoning business, it's growing, it's big, and it contributes, as I said, to the rising financial capital that's available to the plaintiff bar. Phantom damages, another contributor, another driver of social inflation. What are phantom damages? Well, they're the difference between medical costs that are billed and the medical costs that are actually paid. When plaintiffs' medical bills are presented in court that are higher than the amount that's paid, plaintiffs and plaintiff attorneys profit from the difference, and the medical providers that are involved. So the difference is the phantom piece. And in many cases, the amount that's billed is several times higher than the amount that's actually paid. And there's fraud sometimes in cases when you have expensive soft tissue procedures such as laminectomies, spinal fusions, and imaging, MRIs, CAT scans that are billed but never performed. And other abuses involve performing unnecessary procedures just to drive up the billing.
Wow.
Now, I've talked, yeah, Canyon.
That's a lot. I want to make sure that we leave some time at the end to answer some questions. I have a couple more for you. Do you want to say anything else on phantom damages before we move on to the next one?
I'm going to move on, phantom damages, because there's something in the report which could be considered controversial.
Okay.
And I'd like to touch on that. There's a lot more that's in the report that we're not going to talk about today.
Yeah,
but
please.
Yeah, thanks. There's because I focused a lot on the plaintiff bar, but now let's look at the other side, because I talk about one of the drivers that does have to do with the defense bar. And in the study, we argue that insurance companies devote more attention to keeping litigation costs down rather than fighting against the indemnity demands. Many of the defense attorneys that we spoke to in the course of researching the study painted a similar picture of insurers that focus on limiting what they spend on defense because that's within their control, rather than fighting ballooning indemnity, which they think is beyond their control. So compared to the plaintiff bar, which can bankrupt an entire industry or a company with bet the farm litigation, the defense bar operates under more financial constraints. For example, in choosing a defense physician to examine the plaintiff, claims examiners may go for the lowest cost option instead of going for the best suited for the case that's got the right combination of expertise and experience and knowledge of the jurisdiction. And defense is often more reluctant to invest in other areas of trial preparation, like mock trials, in contrast to plaintiff attorneys. So the result is that defense attorneys are often on the back foot, outmanned, especially when they face a polished, prepared, aggressive, charismatic plaintiff attorney. It's like bringing a knife to a gunfight. And we've heard also a lot of times that plaintiff attorneys do a better job of humanizing their clients than defense lawyers do of humanizing businesses. So they could do a better job of that.
It makes a lot of sense. It's probably easier to humanize an individual or plaintiffs in that situation. So what can happen if nothing is done, if we just continue on the same path?
Well, if the trend becomes self-perpetuating and court awards continue to swell, we're going to have more and higher lawsuits and higher insurance premiums, more bankruptcies, higher costs of goods and services, and our economy is going to be less competitive. Not a pretty picture.
Not pretty at all. Okay, and kind of my last question before we get into Q&A, what can we do about it?
Right, what can we do about it? Well, I find that there's two broad areas that need to be pursued to combat the perpetuation of social inflationary pressures. One is to influence the development of public policy at the state and the federal levels to reveal some of these phenomena that I've been talking about, to expose them and to control the excesses. And the second is for insurers and defense counsel to adopt and deploy more aggressive strategies to push back and to formally raise objections, to object when there's tactics that violate existing norms of courtroom behavior. I'll try to throw out a couple of examples. On the public policy front, We should pursue public policy education and advocacy to push back against the trend of litigation finance, anchoring, and phantom damages in state capitals. In some states, these are allowed. In other cases, they're not. We could have the creation of broad-based coalitions that go beyond insurers and insurer associations and tort reform groups and chambers of commerce. They could also include credible municipal employees, people from the business side who represent those who'd be hurt, people that are directly impacted. And defense attorneys can aggressively push back against the use of some of the techniques that we've talked about, described in the report, such as anchoring and the emotional appeals, by basically waiving the rule book. Objections that cite violations of the rules of evidence and other checks on excessive non-economic damages. So there's Rule 11 in the Federal Rules of Civil Procedure, which prohibits pleadings for an improper purposes or contains frivolous arguments that have no evidentiary support. And these rules that I mentioned are federal, Rule 11 and Rule 403 from the Rules of Evidence. They also have their state counterparts, because those are like model rules that are also introduced in states and statutes, such as New York, where I'm from. There's Civil Practice Law and Rules 5501, which says that if the appellate division finds that an award is excessive or inadequate because it deviates materially from what would be reasonable compensation, a new trial can be ordered. So I argue defense attorneys should insist that courts play by the rules.
Gotcha. And you hit on something. We've got a couple of questions in the queue. So with the last minute or two that we got here, I want to make sure that we get to these. And you touched on the states issue. So we had a question here that I want to flag. Are you aware of any states that have a strong statutory regulatory program in place for litigation funding? If so, what states stand out?
Right. Well, litigation funding and anchoring and phantom damages, if you color the map of the United States with the states that allow it and that don't allow it, you'd get like a patchwork quilt, because it varies and it is a battle that's being fought. Recently, if I remember correctly, Minnesota allowed it, but it's something that you really got to map out, because there's states that do allow litigation funding and the other two areas that I mentioned, the other two practices I mentioned, others that don't, others that are ambiguous. And these are battlegrounds that are being fought. And this is one of the areas of public policy that insurers and the people associated with them are fighting. So the states vary from one to another. So you really got to know your territory.
I know we're at time, but we got some more questions. So sorry if y'all have to leave us, but I'd love to take a little bit more time and answer a couple more of these if that works for you, Jerry.
Yeah, that's fine. Thank you.
Excellent. So the next one we have is, hi, Jerry. How much benefit do punitive damage caps provide to limit excessive rewards?
Punitive damage caps, a lot of them were introduced in various states, and they do provide limits. In California, it's been capped at 250,000 for several decades. And so they have been effective measures. And a lot of them were introduced for medical malpractice litigation, which was getting out of hand as we talked before. But they did effectively stanch things in Texas, which is where Bush was before when he was governor. And then he basically brought that on a federal level. So they do work. They do work. And there's arguments pro and con about what the amount should be.
Excellent. And one more from Thomas. Thomas asks, Jerry, great stuff. Our analysis agrees with your comments on the cyclicality of social inflation. What leading indicators are you seeing for the pendulum swinging back, besides maybe political leanings?
Well, it's still swinging forward, I think. We don't have signs really that it's swinging back. A lot of the battles that are fought with phantom damages and anchoring are actually being lost. So the plaintiff attorneys are very well represented in state governments in some places. The president of the Senate is a trial lawyer. So we're not seeing that it's coming back the other way, which is why I think the study and discussion is quite timely, because liability insurance does have a lag. We haven't seen all the impact of this in the numbers, and courts have been slowed. So I'm sorry to disappoint Tom by saying that we're not seeing the signs yet that it's swinging in the opposite direction. As a matter of fact, it's moving further into the realm of higher rewards. So let's return it in 6 months or 12 months, and we'll have this conversation again.
Awesome. All right. Well, those are the questions that we had come in. And I think you already, I was going to ask you about the states, but I think you already handled that. So unless there's anything else that you wanted to say on that note, the last thing that I was going to ask, if you wanted to give a little bit of information about where people can learn more.
Yeah, thanks, Canyon. And thank you all for staying with us this afternoon. The report, the study that we did that was issued in December, is an 11-page report, densely worded, 2 columns, single spaced, and it's on the R Street website, rstreet.org, and it's called The Scourge of Social Inflation. Beware that there is a 1-page summary, which is also there, and that's only a summary or a teaser of what's in the full report. And in the full report, you can read about things which we did not have time to talk about today, but we do appreciate your tuning in to be with us. And if you have suggestions on future topics to be covered in the R Street Forum, this is intended to be a monthly event, please do send them in to me or to R Street in general, and we'll be happy to try to work on them. Thank you very much, and thank you, Canyon.
Thank you so much, Jerry. I really enjoyed this. And I posted a link in the chat for the Zoom that goes directly to the study that we are talking about today. So please check that out if you're so inclined. Also, just in general, the R Street website is an excellent reference for the other things that we're working on. So highly recommend checking that out. And I think that's all for today. So thank you all for joining us, and look forward to seeing you again. Thanks, Jerry.